I want to thank folks for joining us today here. This is part two of a series. By the way, each of these programs do stand on their own on practical tips for protecting benefits and trust to maximize settlements. Part one, which is on our YouTube channel, really focused almost entirely on the changes with Medi-Cal here. So if you need something with an immersion into those, the changes since California with our Medicaid program, which we call Medi-Cal, eliminated the resource test. And we spent a lot of time going through, well, how does that affect settlements and that kind of thing. Today, we're going to be probably focusing a little bit more. No, not probably. We would definitely be focusing more on options in California when it comes down to settlements, with a lot of focus on capacity and that sort of thing. My co-presenter today is a colleague we've done a lot of work with, Tanis Kelly, with Sage Settlements here, and we'll have Tanis in a bit give herself a little bit more of an introduction. But Tanis works in the settlement area. She is an attorney, but most of her work has to do with settlement planning and that kind of thing. So, I asked her to join me today partially because once again, Tanis has a lot of experience with different settlement situations. And one of the things we're kind of hoping to get to after we kind of go through the law is kind of step back for a minute, go through a series of case studies here and try to apply what we've learned. Just a little reminder for folks as we get into this. This is part of the Golden State Pool Trust MCLE program. These programs have been approved for MCLE credit by the State Bar of California, so normally that'll work just fine for fiduciaries as well. Our provider number is 14598, and our provider is the nonprofit that runs the Golden State Pool Trust, which is the North Bay Housing Coalition. In this, we have 3 codes that the viewer will need to record to verify participation in the class. And if you need to receive credit, you can do that by downloading the MCLE credit form by going to gspt.org/here attorney resources here, and you can easily download the form. You'll notice with the slides that have the code numbers, it'll actually have a link to where you can find the form. If you just can't navigate the website, you can always email amy@gspt.org. Okay. Anyway, Tanis, can you tell us a little bit about yourself before we jump into this, and your experience when it comes down to settlements?
Yeah, absolutely. So I practiced law for a number of years, primarily on the defense side, and then switched over to settlement consulting full-time about 10 years ago. And in that capacity, I really help plaintiffs in all types of cases across the nation, helping the plaintiffs understand what their options are, the impacts of each option, how it will impact benefits, how it could impact family members, how it impacts their accessibility to the funds. And eventually, once they come to a decision vis-a-vis the options that are available, then we're helping the attorney get approval of that in court, whether that's federal or state court. Every state has a different rule. We're focusing primarily on California today, but our company is nationwide, so we really help clients navigate the court system and available options wherever they're at. And we work often with Steve and his team. And so we thought this would be a good way to show you guys how we work together, how we analyze these cases, how we help the clients understand, the options and pick from those that are available.
And I think it's pretty fair to say that if you have a practice that does a lot of first party work, um, an essential person in the team is going to be your settlement planner. And a lot of what we end up doing oftentimes, because the challenge, the joy, and sometimes the terror of serving this community is these are all individuals. Every case is different. And there's a lot of problem solving that goes on here. And Tanis, I will say one thing that I do appreciate with you and your team is that you folks have actually do get involved and you get after the settlement. I think that makes a big difference for settlement planners, because I've got to tell you, I've got some settlement planners who I don't think they actually have ever seen the results of what they do. It's kind of like having a cook that never eats what they cook here. And, we learn from every single case. These trusts have a long history, to them in many cases. So,
Yeah.
thank you. All that's good and well here. Let's go back to the program here, and hopefully what you see now is my screen. So just for you folks, I'm going to be covering a lot of the first part of this, as far as that's my job, is to regurgitate the law and that kind of thing. Tanis is going to handle a lot more towards the end, but this should be relatively interactive. If you do have questions, please put them in the Q&A. We will do our best to answer them towards the end here. So let's plow into this. Okay. When you're dealing with settlements for a person with a disability, or a minor or a senior or whatever, there's a bunch of things you really got to focus on. And, one that we're really going to focus on is the capacity of the defendant, the person who's receiving the settlement or the award or whatever. We're going to focus on what kind of entities are available. Management issues of these trusts, huge issue. Once again, these things go on and on and on. And I personally think the choice of the right management system is probably the biggest factor about whether these are going to work or not. Long-term planning issues. Once again, these folks are not static. It would be a lot easier if they were, but they're not here. So you really oftentimes have to think through, and I know this is a big part of your work, about what are the different life phases and that kind of thing, and how are we going to meet those needs. And something that I'm seeing more and more is, what do you do if the trust if the beneficiary is no longer dependent on public benefits? What are those options? You really have to think through here the different phases in folks' life, and as we're kind of learning, as we're seeing all these laws change. Here you have to be a little clairvoyant as far as what possibilities might come up. So that's one of the things that makes this challenging. If the client is an adult with capacity to hold assets, or the first question is the client an adult with capacity to hold assets? In our office, we have a number of staff in the law office, and we do the same thing with GSPT, where if you're looking for services before you get started, we have intake people that are going to ask a whole lot of questions here, just so that we can, get an idea of what the need is and that kind of thing. Numero uno, when you're dealing with settlements, is the capacity issue. Part of this is we're going to see if the person does lack capacity here, then the funds are going to need to go down a path where they're going to be under court supervision. And we're generally talking about either guardianships or conservatorships. For any of you that are watching outside of California, here, A guardianship is for somebody under 18. A conservatorship is for somebody over 18. Obviously, we have guardianships of the person and estate, but since we're talking about assets today, we're talking about guardianships or conservatorships of the estate. A self-settled special needs trust under court supervision, or a self-settled pool trust, once again, which can be under court supervision. Um, Once again, just using GSPT as an example, I believe we have cases in about 20 jurisdictions in California that are under court supervision here. Blocked accounts sometimes can actually be pretty useful. There's a thing we're going to go through called the 3611G trust here, and we'll go through the different variations of that. And kind of a new kid on the block here is the settlement management trust, or it goes by different names, but we'll talk about this. This is kind of a hybrid of many of these. And I don't know about you, Tanis, I am finding this to be more and more of a useful tool. I just wish there was a place in the probate code you could point and say, that's what I'm talking about, Judge. But hey, once again, that is our job to get these things through. Now, if the fact is that the person does have the capacity, it doesn't have to be. In some situations, maybe it should be, but it doesn't have to be under court supervision. So we're probably talking about a self-settled trust under the Fairness Act. Before the Fairness Act was passed, the trust had to be set up by a parent, grandparent, legal guardian, or the court. And we had perfectly competent folks that we had to go to court to get authorization to do this because an individual themselves could not set up their own self-settled trust. But that was fixed, a number of years ago. So that's no longer true. You might be looking at a pool trust. Once again, if the person has capacity, they don't need a court order to open up a pool trust account. Settlement preservation trust, which is really the more common term for the settlement management trust. In fact, Tanis, you and I could probably come up with naming rights on this, and maybe we should think about doing that. But anyway, you could do a spend down here. You could forego the benefits. A lot of what we focused on in the first session, especially with getting rid of the unlimited resource for Medi-Cal, is we did cover situations where maybe the cost of preserving the benefits is more expensive and more hassle than it's worth here, and those things do happen. So let's talk about capacity. Okay. Now, usually when somebody asks me, how do you know when somebody has capacity and when they don't? My answer is normally is that it's kind of like obscenity. You kind of know it when you see it. That's not going to work in front of the judge. Okay, so we might want to just look at a little law. So here's what the law says. And there's a couple of places to go. Under Probate Code 812, once again, except as otherwise provided by law, a person lacks capacity to make a person is presumed to have capacity, and a person lacks capacity to make a decision unless the person has the ability to do these. One is understand the rights, duties, and responsibilities created by or affected by the decision. Okay. The probable consequences for the decision maker, and where appropriate, the person's affected by the decision, and the significant risks, benefits, and reasonable alternatives involved in the decision. Not a easy set of requirements, but it's something that most people can. Now, as we're going to go through here, the problem with the communities that we serve is you're definitely going to run into cases where people clearly lack capacity. If you're comatose, I think it's pretty clear you don't have capacity. And we're going to have folks where they clearly have capacity And Tanis, I don't know about you, the majority of my folks are somewhere in between, right?
Yeah, I'm reading this and I'm thinking, what about those brain injured clients that we have that do understand the rights, responsibilities, consequences while you're talking to them? But the next day when you talk to them again, they don't recall any of your conversation. That those are the tweeners that Steve and I, debate and keep us up at night. And so we're going to go through some of those cases and what it means for you, what it means for them, how you can protect them by respecting the capacity that they do have.
Right. And we might end up needing to shore this up a little bit. Once again, that's a good example with somebody with a brain injury. They may be able to process things, but their short-term memory may be shot and that kind of thing. So we may be looking at some reasonable accommodations and that kind of thing. We may even be looking at some elements of supported decision making to incorporate in this here, but this is part of the skill of putting this together. So now, as we get into settlements here, what we're going to see jumping ahead is if the person uh, once again does have capacity here, and we're going to go through all these different options. And if they have no conservator of the estate to make the decision, once again, the court cannot make an order having to do with the settlement without the express consent of that person here. And that was added a number of years ago. So once again, merely because the person has a disability doesn't mean that you have to bring it under court supervision here. And if the person does have capacity, the court is specifically not allowed to make an order concerning how we're going to handle the settlement. So options. Is the settlement for the benefit of a minor or an adult with a disability who lacks capacity? If the answer is yes, then what we're going to see is our path is spelled out in California Probate Code 3600 through 3612. Okay, here. And as we're going to see, this is really going to be the crux of a lot of our options. And for attorneys and fiduciaries, settlement planners, and all of that, when you're trying to explain it to the personal injury attorney or the client or whatever, you need to be really in tune with these things. And oftentimes, in fact, I plan to use this video exactly for this. Here is that I need to steer back my referral source to these are the options. And as we're going to see, these are the options, and these pretty much are the only options, although we could get a little creative. We do on occasion, but there are boundaries. So things to consider if the trust must be under court supervision. Numero uno is who can be the trustee and how are they bondable. Now, as the trustee of a pooled trust and an attorney that oversees a practice that does a lot of settlements and we do a lot of accountings, my prejudice is to try to use a professional trustee whenever you can. But what if we have a situation where the family wants to be the trustee? Here, the very first thing you should do before you go any further is to run a bond application on them, because if they are not bondable, they are not going to be able to be the trustee, and that will be the end of that discussion. Now, we might find another role for them as a trust protector or something along that line, but you have to be bondable, right? The other issues are going to have to do with court oversight. And once again, we're going to go through this in more detail. But in California, if it's more than $20,000 that's under court supervision, you're to have accountings the first year and every year after that. And it's a pretty involved process, and I wouldn't say it's exactly inexpensive. No. So moving on. Um, so if we and to me, the flow of these codes is not in order. So you're going to notice I'm going to be taking these out of order. But if we go to probate code 3610 here, what it says is when money or property is paid or delivered for the benefit of a minor or a person with a disability under a compromise, covenant, order of judgment, and there is no guardianship of the estate of the minor or conservatorship of the estate for the person with the disability, the remaining balance of that property, of the money and other property here shall be paid, delivered, and deposited and invested as provided in this article. So we kind of start with 3610, and then it's going to take us one more code, and then we'll go back to the beginning. So our next part of this, when we look at our options, is in any case described in 3610, the court making the order or giving the judgment referred in the 3600 article shall, upon application of counsel for the minor or the person disability, have any one or more of the following options. I see this as the settlement smorgasbord. Okay. By the way, not all of these things are tasty. Some of these, you might want to avoid, I mean, it just really depends on the situation, but let's look at what they're serving here. So first off is that a guardianship of the estate or conservatorship of the estate be appointed and that the remaining balance of the money and other property be paid or delivered to the person so appointed. I will tell you, since the elimination of the resource limit, we are doing more and more conservatorships where we would never have considered doing conservatorships in the past. So, partially is that if they don't need the SSI and we're basically just preserving the Medicaid, this is an option that's become more and more used.
We're also seeing it, Steve, used in tandem with a trust, a special needs trust, where the trust is designed to generate that income and that investment income, but the conservatorship is used to hold an asset that's not going to count against benefits. And so, that buffet, we're starting to see a plate that has a lot of items on it, as opposed to, pre Assembly Bill 133, where, the special needs trust was kind of the one fit.
What size fits all?
Yeah.
Yeah. I mean, in a way, maybe those were the good old days, Candace, but as they start easing these things up, we have more options, which means that, yeah. So, and we'll get back to the conservatorships and all that, but that's becoming more and more of a vehicle that we've been using, including as we get into the settlement preservation trust. Oftentimes we use that avenue to authorize that. It can be deposited into an insured account in a financial institution or a single premium annuity, subject to withdraw only by authorization of the court, and that the remaining balance of any property delivered shall be held under condition the court determined to be in the best interest of the minor or person with the disability. We were talking about this earlier. The court actually has wide authority to do something creative. Will the court do it? It depends on the court. It depends on the judge. I mean, there's a number of courts and judges that if it's not spelled out here, they ain't doing it. But once again, that gives us a lot of authority to hold these things. Once again, after a hearing by the court, we're going to get deeper into this. The remaining balance of the money can be paid to a special needs trust established under probate code 3604. That is our tried and true here for the benefit of a minor or a person with a disability. Once again, you need to give notice to the state director of healthcare services, the director of state hospitals and the director of developmental services at least 15 days before the hearing. My understanding is that those all go to the same desk, but it doesn't matter. You need to send 3 letters, right? And if you don't, you're not going to get to pass that square and go. So there you go. If the remaining balance of the property does not exceed $20,000, any or all of the money can be held under conditions of the court in its discretion that are held in the best interest of the person with the disability. Okay, so if the remaining balance is paid or delivered, or is paid or delivered for the benefit of the minor, all or part of it can go into a Gift to Minors Act account or a California Uniform Transfers to Minor Act accounts. There are some times when that can be useful here, and there are times when doing that can preserve benefits of the minor, especially once again, if what we're dealing with is a Medi-Cal dealing with Medi-Cal under a waiver program. But the thing about it is, at age 18, that is going to become the child's funds, and that's that, right? And I know a lot of planners, a lot of attorneys, a lot of families are just horrified that the funds are going to be turned over to an 18-year-old, disabled or not. Believe me, when I was 18, if I got a chunk of money, I'm sure I would have put it to good use.
Probably a boat, right?
No doubt, a boat and that kind of thing. Once again, this is an area, and here, and we go through the scenarios that we might be looking at other things, like there's this thing called the structured settlement that, sometimes are used in these situations and that kind of thing. So, there are options. 3611G is kind of an interesting animal, is that you can put it in a trust here that is revocable at age 18. And we've done many variations of this. I mean, in some cases, this may be a very good option. The only thing about it is, and the problem you run into is, going back to my observation about being the cook and sometimes having to eat what you cooked, here is that oftentimes we will have an indication that our plaintiff, our beneficiary, is disabled and unlikely to ever support themselves, and is going to need a lot of oversight and all of that for the rest of their life. And sometimes that's just not true. Some of these folks, they will exceed your expectations here. And so if we're in a situation where we just don't know, it might make sense to put it in a 3611G trust, or as we're going to talk about. My preference, quite frankly, is a settlement preservation trust. And then we'll just wait until we get close to 18. And at that point, then we're either going to need to modify the 3611G trust and go, yeah, they really do need the benefits here, and we'll move it into a D4A trust or something along that line, or do something else. Thoughts on that, Tanis? Or
Yeah, I certainly think when you have a young child and you don't know where they're going to be, 15, 16 years down the road, you don't want to start them out in the most restrictive trust that's out there. I think you're going to have some unhappy clients when they turn out that they do have capacity, they're working, and they want to use their money to support their family, help propose to their girlfriend or boyfriend. And, you don't want to tie their hands unnecessarily. So you see these, we commonly refer to them as minors trusts, but you see them serve a real purpose. And I think Steve and his team are great at evaluating whether that settlement preservation trust that has a special needs trigger would be more appropriate, or the minors trust. And if they need a special needs trust, come age 18, we go into court and we move the funds into a special needs trust. But these serve a real big purpose. We use them a lot, that's for sure.
Great. Or you could just deliver the money to the person with the disability. That is our smorgasbord here, and we're going to build on that. But before we do that, we got our first code here. So code number 1 is 6112. 6112. And once again, notice that if you don't have the form, which you can certainly download later, you can find it at gspt.org/attorney resources. Okay, plowing ahead. So court monitored trust under probate code 3604. So if a court makes an order here, once again, to do a special needs trust for a minor or a person with a disability to be here, that is to be paid to a special needs trust, the terms of the trust shall be reviewed and approved by the court and shall satisfy the requirements of this section. The trust is subject to continuing court jurisdiction here and is subject to court supervision to the extent determined by the court. The court can transfer jurisdiction to the court in a proper county for commencement of proceedings as determined by the law. Okay, so a couple things. First off, a special needs trust must be established and continued under this section only if the court determines the following things. Number 1 is that the minor or the person with a disability has a disability that substantially impairs the individual's ability to provide for their own care and custody and constitutes a substantial handicap. Now, you shouldn't just block and copy that and say Bobby is substantially impaired here. And once again, you shouldn't just block and copy that. The court is probably going to want to know a little bit more. A couple places you can get that information. Oftentimes you can, if it's a major case, there's probably going to be a care plan that had been developed here. There's stuff you can lift there. There's stuff normally you can lift out of the petition here. But once again, you have to show there's a substantial impairment for the person to provide for their own care. That the minor or the person with a disability is likely to have special needs that will not be met without the trust. Once again, oftentimes the settlement or the care plan will have information in there. Tennis, I don't know about you. I will see these care plans that say we need $100 million to make Johnny whole, but we're give you $1 million, and by the time we're done, it's going to be 500,000. I mean, you could use that. What else might we use? Thoughts?
Sometimes we look at life expectancy and the escalation of their needs later in life, and how they'll need to rely on, a higher valued, facility care that Medi-Cal can provide. So, it's typically we're looking at that life care plan to substantiate the fact that they need both, their resources and public resources.
Then the last one here is that the money paid to the trust does not exceed the amount that appears reasonably necessary to meet the special needs of the minor or the person with a disability. There is so much conjecture in that. We've rarely been shot down for this. You go back to the settlement plan probably will help. I think I saw one case where the amount of the settlement was greater than what the plan called for. I don't know. I guess it happens, but usually what they're asking for and what they get is just in two different worlds.
Yeah, and typically when it does exceed their anticipated needs, they don't want the family is comfortable having a conservatorship instead of a special needs trust, or a settlement preservation trust instead of a special needs trust. So, if you're considering a special needs trust, it's typically because those benefits are important to preserve.
So plowing ahead, probate code 3605 here. This is the big thing here that you always have to keep in mind, which is that upon the death of the beneficiary or early termination of the trust, there is a claim by the Department of Healthcare Services, the Department of State Hospitals, and the Department of Developmental Services here um, to submit a lien upon death here for any Medicaid they've used during their lifetime. Okay. And that's certainly something to keep in mind. Keep in mind, it's not just death, it's termination of the trust. So we go back to this when we start doing our planning here. If we have a situation where conceivably we might want to unwind this, oftentimes as a planner, I think we have to think about how do we get somebody into the trust, but oftentimes we have to think about how do we get them out of the trust if it's no longer necessary. So the joys of planning. So just to look at this, the difference when it comes to establishment, just basic rules for a self-settled trust as an individual trust or a self-settled pool trust is, once again, both of them, you can set up an account by a parent, grandparent, legal guardian, or the court, or a disabled individual themselves here who has capacity to contract, right? On the self-settled trust, the D4 A trust or the 3604 trust, you have to be under the age of 65, which means 64, before the trust can be established. And this is a biggie. Okay, so doesn't mean 65 in a day. It just, once you hit that, there's a barrier. All distributions have to be for the sole benefit of the beneficiary because there's a lien upon death or earlier termination. They don't want you giving this stuff away and then emptying out the trust because there's a lien upon death. Okay. And the lien upon death or earlier termination for any Medi-Cal, probably to include this, or Medicaid used in any other state during the lifetime of the beneficiary. The self-settled pool trust is similar, but it's a little different. The trust itself is established by a nonprofit organization. GSPT was established by the North Bay Housing Coalition, and is still, once again, we are one of their programs here, so they definitely run it. Different pool trusts have different nonprofits, but they all are run by nonprofits. You get an account that can be established by an individual, parent, grandparent, or the court. So once again, whenever we're doing this under court supervision, here we're having the court authorize the establishment of the account. All disbursements must be for the sole benefit. I think we're going to cover a little bit about age limitations, but there is no age limitation in the statute here for a pool trust. And there still is a lien upon death for any Medi-Cal used during the lifetime of the beneficiary here that's to be paid to the state of California for any assets not retained by the trust. I'll just mention this for GSPT. We are starting to put in our joinder agreements that if there is no possibility of getting anything to a remainder beneficiary, then the Golden State Pool Trust takes nothing. We are now, if there is no chance of getting anything to the remainder beneficiaries, we are now looking to hold half of the funds so we can use it, quite frankly, to offset care management costs here. So once again, so Now, a big player here, and I'm going to make sure that this is in the Dropbox with materials. And this is something that for planners and attorneys and all that, you should always have this bookmark, have it ready to go. I send it off to a lot of attorneys all the time, just to illustrate that I'm just not making this stuff up. This is what it says. Rule of Court 7.903 has to do with any court, any trust funded by a court order. So if the trust is funded by a court order, then it's going to be under continuing court supervision here, and which is really important. And that the order must provide that the trust is subject to continuing jurisdiction of the court, and may provide that the trust is subject to court supervision under the probate court code, getting into the meat of it, except as otherwise provided, it not contain a no contest clause, prohibit modification or revocation without court approval, clearly identify trustees here with authority to direct the or other persons that have authority to direct the trustee to make disbursements, prohibit investments by the trustee other than those permitted by probate code 2574, require that bond be posted. Once again, oftentimes this is the linchpin, especially when you have a family member that wants to serve as trustee. Here, require the trustee to file accounts and reports to the court in the manner required under the probate court. Require the court to approve changes in trustees here, and require that any compensation of trustees, advisory committee members, or attorneys for the trust to be just and reasonable, and basically be subject to court approval. Right. This is the one that really gets me, and I just got to tell you, I'm hoping we can change this. This at a certain level is ridiculous. All this must be done for any case over $20,000. Now, in a lot of cases, once again, it's a court of equity, and I've had cases where maybe we're talking $30,000-$40,000, and just going with the court. I mean, the problem with this is on like a $30,000 trust or an account. And if you kind of figure that the average accounting is somewhere between $2,000 and $4,000, if nothing wacky happens here, you can see with a $30,000 trust, between accounting fees and filing fees and all of that, you can eat this thing up pretty quick without getting any benefit whatsoever to the beneficiary because of these rules. I personally think the $20,000 is a ridiculous number and it needs to change, but that's what's on the books. So our second code is 2424. This is code number 2. So if a client is an adult who does have capacity, it may not be under court supervision. Candace, I'll tell you, my experience is the most hazardous cases are the folks that technically have capacity but have severe challenges. And I have to tell you, I have learned the hard way that cases where you technically don't have them brought under supervision, you might want to rethink that. Or the other problem with that is, if you're not going to have it under court supervision, you better have something in that trust that is going to be super vigilant to make sure that nothing overly bizarre is going to happen. I don't know.
Yeah.
So
No, I think those are the challenging ones for sure.
So the pros of not being under court supervision is that once again, they can establish the trust without a court order. Certainly going to be a lot less expensive, certainly going to be faster. The trust will not be under supervision, therefore will not have a requirement of bond or court or accountings, potentially reducing um, uh, um, the amount of money that's going to be available to actually help our beneficiary. In the end, I think that's what we're supposed to do. But, to get there, we got to get through all this. Now, the con is it won't be under court supervision because there are no court accountings. So the chances of misadministration or something going wildly wrong without you knowing it is really significant, right? Here. So really, once again, for the attorney or for the planner and that kind of thing, in a lot of cases, after the thing is all set up, if it's not under court supervision, you may have no idea what happens until something just goes horribly bad. And then they come back to you and say, well, the trust isn't working. Well, once again, I'm sure the trust is fine. It may have to do with the administration. Persons with marginal capacity are very susceptible to fraud. People with good capacity are highly susceptible to fraud too, but there we go. Because there's no review, something can go wrong without detection, causing a large overpayment to SSI or Medi-Cal, or even worse. I'll tell you for myself, part of this is whenever I'm doing this planning, in the back of my mind, I'm going, where is this going to go wrong? Right? There's a part of this is that having a healthy paranoia might be a good thing, right? Here. And so in a case like that, I might want to make sure there's a care manager watching going on. I would really be more comfortable having a professional fiduciary, involved in these things. What really concerns me is the family managed trust. People entering in the best of intentions that's not under court supervision. And once again, it can be really problematic. So
the other thing I like is, the bond is relatively inexpensive. And if you have an individual trustee or a family member, putting that bond in place, even without the court requirement, protects that beneficiary. And I think if, we're in a position to understand the deficiencies that in capacity that individual has, even though they still are legally have capacity, they're not, they are susceptible. And so putting that bond in place protects us, protects them. And it really is a small cost overall.
So under the Fairness Act, an adult who is under 65 can establish their own trust here if they have capacity to do that. No court supervision required, no bond, and must account to the beneficiary, but accountings are not under court supervision here. I mean, this would be another thing that, let's go back to the situation with the person with the brain injury who definitely has capacity, but has problems with their short-term memory. You might want to make sure that the accountings are made to somebody who does have capacity or whatever along that line, because the person might have capacity, but the accountings may mean nothing to them, and so that's pretty ineffective. Under federal law for a D4C trust, once again, must be disabled here, but technically there's no age limitation for these things. Although there have been cases in other states, this is yet to happen to us in California, where folks have been knocked off of SSI in a pooled trust here. I've yet to have that happen to GSPT, but once again, there is a possibility. Do I really need a trust for my client, or is there an alternative? Well, part of this here is we need to put a value on the benefits. Once again, I think especially, and I covered this a lot in part one, currently in California, the SSI rate for a single individual is $1,192.94. We're talking $14,000 a year. Now, it's not like that's not a consequential amount of money here. But, in a case like that, I think that we've had a knee-jerk reaction for years and years and years. We got to preserve that SSI. I think more and more we need to look at this and ask ourselves, is the $14,000 a year worth this being subject to a lien upon death? For instance, and that kind of thing. I think that we covered that a lot in the first part, but I think that since the change with, especially with the Medi-Cal rules, we need to put a lot more thought into that. Once again, Medi-Cal covers basic expenses, medical expenses, as well as in-home support services. There are some behavioral health treatments and long-term care that can only be got by Medi-Cal eligibility. So in many cases, it's incredibly valuable. In some cases, if it's just covering basic medical care, there are cases where Covered California works just fine, right? And here, I mean, for the majority of the clients I work with, they have a lot of needs, especially attendant care needs and that kind of thing. But it's something to look at. If they're on SSI, if they're on Medi-Cal, so if they're getting Social Security disability, either childhood disability benefits or just Social Security disability, they will qualify for Medicare 2 years after receiving that here. And in that case, Medi-Cal pays the copay, but it also, once again, Medi-Cal is more valuable to some folks than others, just like the individuals we serve. The answer for one person may be completely different than somebody else. Once again, this is where a good settlement planner, I'm a big believer in care managers and what that can help us oftentimes quantify what are the value of those benefits. A couple of considerations here. Special needs trusts are relatively easy to create, but they're really difficult to unwind in some cases. Medi-Cal lien upon death or early termination of the beneficiary oftentimes is an issue. The trust must be for the sole benefit of the beneficiary, cannot be used for gifts or to support other family members, and the trustee has sole discretion and the beneficiary has none. Number of things to consider here. But with that, let's jump to the next part. Candace, can you tell us something about maximizing settlements and practical tips for protecting government benefits?
Yeah, absolutely. So, Steve has covered some of this, but the cases that we're going to look at are going to look, predominantly at what if you have a competent minor that upon age of 18, they are going to have the capacity to manage their funds. And how does that differ from a minor who is not going to be competent to manage those funds at 18? Or an adult that doesn't have capacity. And then those kind of hybrid cases where someone may have capacity, but it's compromised. And it puts us in an ethical position where we need to make sure that they are adequately protected, even though they don't rise to the level of court oversight and court mandated protection. And then we'll go over the procedure for getting a settlement approved when you have someone who doesn't have capacity or has compromised capacity. As Steve mentioned, these are in Probate Code 3600. They are also in the Minors Compromise and Incompetent Adult Compromise Petition, which is MC 350. It's a form that you would file with the court to get approval if you're in state court. It's also a good template to create your petition to get approval if you're in federal court. The three common options that I'd say we see the most are, 19B3, which is a single premium deferred annuity, and a special needs trust, which is 19A or B or A or B4, and a blocked account. Or a minor's trust. Those are kind of the main options that we see most often. But as Steve has highlighted, it's a buffet, and increasingly we're seeing a combination of these items kind of used in especially in big cases, but you'll kind of see through these examples where we're using each of these different options. And so, we're going to go through, this is a competent minor, and I used, what I tried to make as the most simple case. We have a 2-year-old who was bit by a dog. There was, past medical needs, but there's no future medical needs, and there's no immediate costly items that the parents need to use the settlement funds for. this minor is going to receive $100,000. Now, these are the common options. You could also do a guardianship for that minor, and you could put the 100,000 into that guardianship. Now you're going to have court oversight and bonding. If you do a blocked account, it is a blocked checking account, blocked savings account, and you cannot access money unless you get a court order. It's also growing at a fairly conservative interest rate, and it's going to be taxable. And at age 18, this child can take all of the money out. A minor's trust, I want to go back to actually the blocked account. The blocked account serves a really good function when you have a child who's bit by a dog who may need a scar revision surgery that would be cosmetic in nature, not covered by insurance. You might want to put some money in that blocked account for that isolated potential need. If, at age 15, he or she wants to get that treatment, he can petition the court to pull out the money for it. And so it kind of is a nice carve out that it's there if you need it, but you're not paying that ongoing accounting and court oversight fee that the minor's trust would have. And then the structured settlement annuity is really an ability to take those settlement funds and earn interest on them that's tax-free while they're deferred and have it pay out after 18. And so I'm going to walk you through two different samples for a minor that's 2 years old that we often see because parents don't always want to hand all of this money to their 18-year-old. So they want to choose now when it gets distributed. So if you look at this option on the left, this is a fixed structured settlement annuity. And it's provided in this case by Metropolitan Life, which has an A+ rated company that's been around for 155 years. And they are guaranteeing, we design this and you can customize it for the needs of each individual. But this is providing $20,000 a year for 4 years to help with college. And that's from 18 through 21. And then a lump sum at age 22 of $50,000 and the remainder at age 26. You can see that this is a initial investment of $100,000, the full settlement, and it's going to pay out a guaranteed $261,453 between the ages of 18 and 26. This is very common in a case where you have a minor who doesn't need the money until they're an adult, and you have a family that wants to pace their receipt of the funds. This second option is a market-based option, and this is a newer development in the structured settlement world and space. And so in this scenario, we took the same 100, we are deferring it in an indexed annuity, which means it is tied to the S&P 500. In years where if there's every 5-year period, they're locking in the gains that the S&P 500 has had, up to 67.5%. And so if we look at taking that 100 and having it pay out from age 18 to 26, it has a forecasted growth. If you look at it has a minimum growth rate of 1.12%, even if the S&P 500 is never positive. But historically, it is more likely to be in the 6 to 8% range based on the most recent index values and the highest index growth. And so when you have someone that's so young and you have a family that is, maybe of means or more open to market performance, blending a fixed and a market-based option may maximize that potential for that child. These are not, you can blend these together and do half and half. You can do all market or all fixed, but really working with the family to design this is where they're going to direct how they want their kids' funds invested.
Dan, it's a couple of things. Just going back to basics. I know no judge, no attorney, no parent is wild about their little darling getting their hands on the money when they turn 18, disabled or not. And, if you look at all the options, especially if the person has capacity, other than a structure, what's the alternative to stretch this out after age 18?
the only option that's an alternative that gives the parent, the ability to direct when they get it is really a minor's trust with a Hail Mary that they don't, because it has to be revocable at 18.
Right.
And so we sometimes get creative and we give them a period to revoke it. And it may be a brief period of, a couple months. And if they don't revoke it at 18, that minor's trust continues until 22, 25. But they always have to have that ability to go in and revoke it. So it's not, it's not foolproof. And so this is really the only way that a parent has to ensure that the funds are spread beyond just 18.
That's been my experience. I'll tell you, when the 3611G came out, we kind of treated it like a crummy trust, so that we would give them like a lapse period. So like if junior between 1201 and 1215 revokes it, then, and technically it was revocable. And we had some judges that went with that. Then we had some cases later that we had 2 cases later that came up where the child got an attorney and basically went back to court and said, look, that's, and the parents are going, but you're just going to do something stupid. And the answer is, so, right? I mean, but so this tends to be the way to do it. The other part of this is, Tanis, you hear all the time on the TV, especially on the national channels, it's my money and I want it now. So are they just going to turn around in California and sell that sucker for pennies on the dollar?
Most likely not.
Yes.
I've been doing this for 10 years and I've had, I do over 250 structured settlements a year. And I've had one individual who has sold a structure. So it's not as common as it's advertised, but that is a catchy jingle. And what we see is that if you do want to sell a structure, you have to go into court and get the court authority. And so it's an opportunity for, anyone involved, including a settlement consultant, to connect with that individual and say, what about a credit card? What about a loan? What are we looking at? Why are you needing to do this?
Yeah.
You're a student. Let's take out an interest-free student loan. But it gives you an opportunity to, 1, articulate to the court why it's not prudent, 2, intervene and help that individual find alternatives to meet their needs. So it's not as common as some people fear. The other thing to consider is we can do a combination. And so sometimes you see a minor's trust for $50,000, and then you see the other $50,000 deferred to age 22 or 25. And I think when you put that all in front of the court and you articulate, we want them to have access to money to pursue what they need, but we also recognize that, a young adult's brain isn't fully formed until they are a little older than 18. The court is going to be receptive to that. So hybrid plans are typically being used, when a family wants that flexibility.
Although I think my wife might say that it hasn't fully formed to 72, but that's another subject. Okay, so anyway, let's get into some case studies.
So this is a case, we have an adult with extensive needs and no capacity. So this is a 30-year-old in a semi-vegetative state. They will never walk or talk. They're reliant on a feeding tube. They are largely bedbound, occasionally in a wheelchair, 24/7 care, receiving Medi-Cal in-home support, and they're anticipating a net of 5.6 million. In a case like this, we're looking at what are the options, number one, and what are the immediate needs, the ongoing needs, and the ongoing expenses. And this is kind of a flow chart, a hypothetical flow chart that could accommodate someone like this. And so this is where we talk about, they want to maintain these benefits because they are providing significant caretaking coverage. And based on, potential life expectancy and increased needs, we don't know if there's enough to fund that without benefits. But if this person were to purchase a house and it's inside of the special needs trust, Medi-Cal has a right to reimbursement and they could take that house. And so if the other family members are living in it and they, it's their primary residence, it it is beneficial to have this in a conservatorship where we can protect it from, Medi-Cal's grasp. Here we utilize a special needs trust to help fund those immediate needs and those ongoing needs, as well as, the trust attorney and trustee fees. And then we utilize a structured settlement that can feed money into that special needs trust at a rate that we expect will cover those ongoing costs. This allows those funds in the trust to be invested slightly more aggressively. We allow them to accumulate and compound without needing to be depleted on a monthly basis. And we're earning tax-free interest on that structured settlement that's not subject to trustee fees. So we're saving that 1.5% on all of the funds that are utilized in the structured settlement. So this is a flow chart that shows you how you can utilize a lot of the tools to put together a plan that kind of meets those anticipated needs.
And I think part of this, and I have to be careful about time, is it doesn't have to be all or the other, right? Yeah. I mean, in fact, it's probably best if it's not all structured or all invested. Basically putting your eggs in one basket. So, and I know we could get into what is over structuring and how do you define it. And it's kind of like obscenity. You know it when you see it. And we do see some stinkers on occasion, don't we?
Well, and I always say, needs are not linear. Especially for someone that's profoundly disabled. And so a linear structured settlement that goes, 20, 30, 40 years, that is not going to meet their needs. Their needs are not going to be precise the same every month. And so it's so important to have that large, pocket of cash that is liquid that they can access when the roof needs to be replaced. They need a new adaptive van. They need a higher level of care. And it depends on the client, obviously, but liquidity is very important.
Okay, plowing ahead.
Perfect. So this is a case that, Steve and I debate, I'd say ad nauseum, because these are those ones that are kind of wobblers. You have someone that has compromised capacity, but they have capacity. And you have an attorney that's built up a case. They have neurologists, they have experts, they have a life care planner, they have deposition testimony, building up how compromised this person's capacity is. And that database of, compromised capacity is what has in turn produced a huge settlement. Now, is that attorney going to turn all that money over to someone who we have a huge record that they can't execute higher functioning, good judgment, good memory? And what does that tee the attorney up for? And so, we're looking at what options are available to help protect the client, the attorney, the settlement consultant, the trust attorney. And this is where protective trust, essentially an irrevocable settlement preservation trust, has really been a great tool for clients. Here's a case, I kind of went through these facts, but you have a client who was in a high-speed motor vehicle collision. They were in a coma for an extended period of time. We have multiple expert witnesses that, and treating physicians that have said there's a brain injury. The life care plan says eventual need for 24/7 assistance, even though he or she doesn't need it now. And the client has an understanding of what's going on and is sophisticated, but also has appreciable deficiencies. What is the right call in a case like this? I think Steve and I prefer to have some layers of protection for this individual. If they're going to need 24/7 care at some point, how do we know when? Who's overseeing them to help them make sure that they're not susceptible to mismanagement, to fraud, to, bad investment advice. And so this is where working with them to understand the benefits of a fiduciary, the benefits of a care manager, the benefits of an irrevocable settlement preservation trust that gives them the autonomy and independence they want, but also provides that level of oversight that can, protect them if they are having any susceptibility.
And if I'm the attorney in this case, or one of my attorneys, by the way, I would not be the attorney in this case because I don't do hands-on. But if one of my associates were doing this, I know the big focus would be that, okay, maybe we're not bringing this under court supervision, but a, a professional trustee, a corporate trustee, a private professional fiduciary, or should I say a pool trust, might be in order. Here, I probably want to beef up um, um, trying to track things. A care manager would be more. I mean, you should have a care manager anyway, but having this all documented and all of that, I think it probably behooves you to be a little bit more intense about having a system of oversight, because you go back to this. One of the examples, we get a lot of folks with brain injuries. Are they incompetent? No. Are they compromised? You betcha, right? And are they subject to being taken advantage of and all of that? Absolutely, right? As I said, a little paranoia probably is a good thing when you're doing this. Now, for our last code here is 3451. That is 3451. Okay, let's get going and see if we can bring this home. Okay, so here's a once again an example that maybe we can look at. John's receiving a settlement of $800,000, which left him paraplegic and initially unable to work. The settlement was placed in a self-settled special needs trust, which preserves his eligibility not only for SSI and Medi-Cal, but also for in-home support services, which pays for attendant care, right? Despite his injury, John, after much vocational training and physical therapy, was unable to become self-supporting and eventually was able to get private health insurance and no longer dependent on SSI, Medi-Cal, or in-home support services. John, you're ruining my wonderful plan here. But John would like to unwind the trust here, but if he were to terminate the trust, then most, if not all, of the funds would be taken on a Medi-Cal lien, because if he's used a significant amount of Medi-Cal, for instance, for attendant care, it's amazing how fast you can rack up some pretty big bucks there. Here, as an alternative, if the funds were used to purchase a home for him, which is an exempt resource, then the trust would not be terminated. The funds would be exhausted. One of the things I know when I interview somebody, especially in John's case, I'm going to ask him a couple of things. One is, what would you like to do with the money here? But the other one is, what is, or maybe even the parent, what is your best vision of your future? And then I'm probably going to introduce that, like, what if you get a job? How are you going to do this? Sometimes when you're planning, you need to plan on how you get them into the trust. But oftentimes you need to plan about how are you going to get them out of the trust. So in a case like this, if John were somebody where there was a possibility of him getting a job and getting off this benefits merry-go-round, and believe me, no rational person wants to be on these programs if they don't have to, right? We don't want to condemn John to having to deal with these things. Part of my plan will probably be, well, if you get a job, and let's say there's still $400,000 left in the trust. And for those of you that are not in California, you 400,000 is probably a nice down payment in a lot of situations. It might buy a house in the Central Valley, which we love the Central Valley or whatever, but that's not going to get you a real fancy house. But it might be that you want to use the money to buy an exempt resource or whatever. But if you see what's going on here, part of this is trying to come up with a plan about what if John is able to become self-supporting and the trust no longer does its job. And that happens. In fact, it happens a lot. Beth's story. Beth is injured from birth due to a medical malpractice during labor and has serious physical injuries. A lot of our large cases are birth injury cases. Despite her injuries, she's cognitively fine. It's unlikely that she will qualify for needs-based benefits until she turns 18 because the parents have substantial assets. There's a concept called deeming where the parents' assets are deemed or attributed to the child. So, for instance, if it's a family, the family can't have more than $3,000 if they're looking for SSI. Very few of our children are on SSI. Medi-Cal had pretty much the same rules until last January. And now the rules have changed, which means that Tanis and I and all the other planners got to work a little harder here to figure out what's right for Beth. Okay. So it's unclear how important it will be later in life about her to qualify for SSI or Medi-Cal. So rather than put the funds in the special needs trust, the funds are placed in a guardianship of the estate because that's what I wrote when I wrote this. I really like settlement preservation trust. And maybe we can talk about that a little bit here after we run through this scenario here. Some of the practicalities of that here. But the problem with going straight into the special needs trust itself, the D4A trust, is that if it turns out that Beth really doesn't need SSI, or it's not desirable, or the laws change, or whatever, the only way to get out of that trust is either to spend your way out or pay a lien upon early termination. So at some point, once again, if it goes into a guardianship here, or even a settlement preservation trust, then a decision is going to be need to be made when she gets closer to age 18 about what path should we go, right? Rather than lock ourselves into here from birth that it's going to go into a special needs trust, and that's that.
And I think the problem with putting it in a special needs trust for someone who's, competent and has a potential to live a fairly normal life is if she does want to start a family, start a business, even take her, loved ones to dinner, she can't use that money in there to do that. And she's going to be really upset with you, fast forward 20, 30 years when she has children and she has a large sum of money inside of a special needs trust and she cannot pay for those kids, to go to preschool, to go to summer camp, to pay for clothes for them. So this is where the guardianship of the estate, the minors trust, or the settlement preservation trust can be drafted in a way and can allow her that flexibility to, her needs are not linear. We don't know where she'll be, what she'll need. They're a lot more flexible than a special needs trust.
I think we have one more scenario, so let's see how this goes. Robert is a victim of an automobile accident, left with a traumatic brain injury. While Robert has capacity to receive the funds, he and his family recognize that he has substantial challenges, and they would like the money to be managed by a professional trustee. Probably because Jennifer, Olga, and I hammered on them to get a professional trustee. It's hope the settlement he receives will be adequate to provide for the needs for the rest of his life, but it's unclear what his future needs are going to be. Robert has the settlement placed in a settlement preservation trust. We keep going back to this thing, which will be managed by a professional fiduciary. Under the terms of the settlement preservation trust, the trustee does have the option to convert the trust into a self-settled trust at a later date if it is in his best interest. Tanis, we've talked around this animal that we're calling a settlement preservation trust. Let's try to define this a little bit more here. There's a number of ways of doing this, but what the settlement preservation trust is, it's a grantor trust, because in this case, it's Robert's money going into a trust for Robert's needs for it. So it's a grantor trust. So for tax purposes, all the income's going to flow through to Robert, here, whether it's expended or not. And basically it would be a trust that would be for his personal needs and that kind of thing. And up until recently, it would mean a loss of his SSI and Medi-Cal. But wait, here, since it doesn't have paybacks and that kind of thing, here it would preserve his Medi-Cal if he stays in California. Wink, wink. Here, because with the unlimited resource limit, the only thing we're concerned about is income. Now, normally it will have a standby special needs trust, and this can become significant here. So it's basically has a situation where you can trigger this into a self-settled trust if it seems like it makes sense, or you can leave it as it would. Tanis, why would we trigger it into a self-settled trust?
Great question, Steve. A lot of times we have someone like Robert who has kids that are young and he needs to support them, but his money's not sufficient to take him to the end of his life. And so having this hybrid that he doesn't have to trigger the special needs portion yet allows him to support his kids, but still preserve access to those benefits down the road. So that's one example. You may also have a client who doesn't know if they're always going to live in California.
Really?
Family in Tennessee, and they may want to move there.
So this won't work in Texas, huh?
The Settlement Preservation Trust won't. No.
Right. So I like to say our biggest export in California is Californians, so what if he goes to another state and he really does need the Medicaid and all that? So, it's a one-way door.
It is. And it's very nice for someone. I mean, if Robert wanted to have a lot of funds in his trust, but he also wanted a structured settlement that's paying into the trust, it's very easy if it's paying into a trust that has that special needs trigger and can convert to a special needs trust, as opposed to having to go into court, move that structure from one trust to a special needs trust. It's really seamless. And so he has one document. It allows him the potential to access additional benefits if he needs it. But if all goes well for Robert, he won't need to. And he preserves flexibility and he doesn't have to pay back any Medi-Cal.
Well, and the thing with it in this case, I think where this is going to become more and more the tool to use is that under the change under AB 133, if this trust, conceivably the trust itself could be managed by Robert. I'm not going that far. If we have this managed by a private professional fiduciary or something along that line, here we actually can have our cake and eat it too, because we can keep him qualified for the Medi-Cal. If you go back to part one of this program, I went into ad nauseum, and I'm not going to do it again, about the new rules, having to do with what's counted as income and what's not. For those of you that don't watch part one, do not use common sense or common knowledge of trust income. It doesn't work. You got to follow those rules, but they're not that hard once you get your head around it and that kind of thing. This really does truly give us the best of all worlds. Now, how do we get this through? I was talking to Jen today. No, you cannot convert a D4A trust to a settlement preservation trust. That's going to trigger the payback. So this is something you need to do from the beginning. In some counties, I just went through with Jen, we've done this in many, many counties. We only have one county we had a problem, which I won't mention here online, but it was here. But we've done it as part of a conservatorship. We've done it as part of a 3604 petition, because remember, there's a D4A trust in there, right? So if we've had more and more courts that have said this makes a lot of sense, and our argument has been, and it technically is a 3604 trust here, and by the way, the courts have bought it here. So, I mean, any number of ways to get there. Your experience with this, or?
That's been my experience as well, is that courts, once it is explained the dynamic that it allows for that protection should they need those benefits, but it also gives them, a little bit more flexibility and autonomy early on. The courts have not had a problem with it, in my experience, but it does take finding the right box to check because there's not a box for a settlement preservation trust.
Right.
Yeah.
Okay. So,
This is really quick, but when you have a settlement involving someone with a lack of capacity, whether they're a minor or an adult, there's kind of a procedure to get that approved. And so first you need to appoint a guardian ad litem for the case. There's a form, I can send it to you. I didn't include it in here, but you can file that with the court. Then there's a settlement and trust planning that goes on with that individual's family and the guardian ad litem to figure out what's the best plan for them given the options under probate code 3600. Once that plan is designed, then it's drafting of the compromise petition, and that in state courts that MC 350 or 350 I think it's expedited petition for certain cases that are under 50,000 or a policy limit with no trust and no allocation among other plaintiffs. And in that compromise petition, you're checking the box for how you're allocating this money. What's the type of trust? Is it a blocked account? Is it a structure? Is it a guardianship or a conservatorship? And you're laying all that out there. You file that with the court. You get a hearing date. At that hearing, you bring the individual, their guardian ad litem, and you answer any questions the court has about, the selected settlement plan. And then the defense will fund it once that's approved. It's kind of important that all of these pieces go together because when you lock in a structured settlement, from our perspective, we're using a funding date. And if the petition isn't filed in a timely manner and the hearing doesn't happen or funding is late, those rates that are secured for the client are in jeopardy. So, I think having a team that can make sure it's a really well-oiled machine is important, and really taking into account the client's individual needs, because Steve and I have worked on hundreds of cases together and no two are the exact same.
It would be a lot easier if they were. I'm here to tell you.
Yeah. Sure would, but it'd be boring.
So let's mention real quick once again what I call the most terrifying part of the presentation. Do we have any questions? Okay, and hold on. I'm gonna stop the share. I know there was one question that I did see, which was when will these materials be available? My expectation is that the video will probably be available this afternoon or tomorrow. I want to get this done pretty quickly. By the way, we do have all sorts of different programs and more programs coming up and that kind of thing. For whatever reason, I cannot. Oh, there it is. If we don't have any questions, I just would like to go through a few things. Tanis, any last thoughts before we jump into this? Any words of wisdom?
Well, I have one question actually. So we talked about how a special needs trust and a pooled special needs trust differ and how they're similar. With regard to the notice, the 15-day notice to the Department of Health, is that the same for a special needs trust, a pooled special needs trust, and a settlement preservation trust with a D4A trigger?
It definitely is for for the 3604 trust, whether it's an individual trust or a pooled trust. We basically are doing the same thing here. And it's interesting. I think we have been noticing if it's a settlement preservation trust because of the special needs trust here, the standby special needs trust part of this whole thing. So it would be prudent to do that here. Once again, my expectation is we're going to see this more and more. My hope is, and as many of you know, that I do a lot of policy work, so I've got to tell you, top of my list next year is to raise the amount of money that has to be under court supervision from 20,000 maybe to 50,000. For those of you that are on the listserv, we'll be having more discussion about that because that's definitely on the list. The other part of that is I think the Settlement Preservation Trust is a very important tool that makes a lot of sense, especially with the changes in Medi-Cal. I don't think our laws have kept up with that. So I would love to see if there's some folks from CAOC or other organizations, CLA, that should be very high on our list because here we have all these options and we need to have clarity about how we can use that for the people we serve here. So anyway.
One other kind of closing thought or wisdom, if you will. Who serves as a trustee is really important because some trustees have internal rules about what you can use out of the trust to purchase a home, for example. And so knowing what your clients may want to do and when may dictate how much they need liquid in the trust. And I think a lot of clients think that within a special needs trust, they're going to take out a mortgage and that they need a down payment. And they don't realize that that's not realistic, that it's going to be a cash purchase if they purchase a home due to the Medi-Cal repayment. And so, really looking at the amount that's seeded into that trust, if there's a structure supplementing it, it needs to be much higher depending on who the trustee is, depending on if there's a house purchase that's desired, and depending on those immediate needs. You can see that they can quickly be pretty substantial for someone who has profound needs. And so that's, I think, how you prevent and you allow this to all work together and prevent any dysfunction of that trust.
Well, I think this is kind of a good thing to end on. I mean, I'll give you just one last, just piggybacking on that, Tanis, is if you're involved in petitioning, we're talking about somebody that has a capacity issue where it's going to be under court supervision. If you have a case where there's likely to be an unusual disbursement, what is an unusual disbursement? It's like obscenity, when you see it. But buying a house, I think, is universally a unusual disbursement. Paying substantial attendant care probably is an unusual disbursement. Here, my advice is that when you bring the petition, rather than do that and then turn around and bring a petition for these unusual disbursements, do it in the same petition, right? Especially if this is really important. And I will tell you, housing, which could be a whole different program, and blessedly we've run out of time, so we don't have time for this. But housing, I think, is one of the biggest issues we deal with here. And the whole process of not only securing the house, but making sure it's maintained and all of that, it's not a simple thing. And usually best just to tackle that right up front in the initial petition, rather than file the petition to set up the trust and then, once again, turn around and file another petition and wait, 3, 6, we're getting dates into October now, October and November, here with the family hanging on because they want to purchase a home. I want to thank everybody for joining us today. Remember, this is part 2 here of a 2-part series. So if you get a chance, definitely watch part 1 about the changes with Medi-Cal rules. If you're out of state, I'd suggest don't watch it because it's just going to confuse you here. So anyway, I want to thank you so much, Tanis. By the way, I want to thank Amy Tesler, who puts a lot of this together and keeps us on track here and all that. So for those of you that haven't worked with Amy here, Amy does an incredible job to keep everything on track, maybe with the trustee that needs a little nudge once in a while to go. With that, any last thoughts?
Thanks so much, everyone.
Great. Thank you very much, and happy advocating. Bye.